The role of the Office for Civil Rights in advancing rights for disabled parents, safeguards in child welfare cases. Next slide, please. Today, we are glad that you could be here to join our webinar. For those who need it, we have American Sign Language interpretation and closed captioning. We are recording this webinar. Please hold your questions and answers to the end, which you can then put in the chat. At the end, we will also have resources for you. We very much appreciate your feedback, so we will have a link which is actually already in the chat, https://brandeis.qualtrics.com, where we would like you to let us know what you thought of our webinar. Next slide, please. For those of you who may be using American Sign Language, ASL, we do have interpretation. There's a button at the bottom. If you click on that button, you will see the ASL interpreter pop up. We do also use Zoom closed captions. So if you click on the CC button, the closed caption button, which you can find in the three little dots, if you click on the three little dots, it will pop up if it's not on the bottom of our already, and you can use those. So next slide, please. Our speakers today are Carla Carter. Carla Carter is an Associate Deputy Director for Enforcement with the Health and Human Services Office for Civil Rights in the federal government. She provides direct and ongoing supervision to staff implementing nationwide compliance and enforcement programs to protect the civil rights of children and families involved in the U.S. child welfare system. Ms. Carter develops civil rights policies, drafts regulations, and provides technical assistance to child welfare entities and courts to ensure compliance with civil rights laws. Ms. Carter holds a JD from the City University of New York Law School and a BA in Early Childhood Education from Lincoln University, and we are honored to have her with us today. With us today also is Attorney Robyn Powell, who is a Senior Research Associate at the Lurie Institute for Disability Policy, an Associate Professor of Law at the University of Oklahoma College of Law, and soon to be an Associate Professor of Law at Stetson College of Law in Tampa, Florida. As a disabled woman, Dr. Powell has dedicated her career to advancing the rights of people with disabilities and is one of the foremost authorities on the rights of disabled parents. She is the principal author of the National Council on Disabilities, Rocking the Cradle, Ensuring the Rights of Parents with Disabilities and Their Children. She has written extensively on the rights, needs, and experiences of parents with disabilities. She's been an invited speaker at the White House Forum on Civil Rights of Parents with Disabilities and holds a PhD and master's degree in social policy from Brandeis University, a Juris Doctor from Suffolk University Law School, and a Bachelor of Science degree in social work from Bridgewater State University. We're really pleased to have both of you here today. I'm your facilitator. I'm Linda Long-Balil. I'm an assistant professor at UMass Medical School. Next slide, please. And of course, this webinar is hosted by the National Research Center for Parents with Disabilities, which is a cross-disability initiative guided by the ethos of the disability community, nothing about us without us. We do services, research, and advocacy. We provide information and support for parents with disabilities and their families as part of the Lurie Institute for Disability Policy at Brandeis University. And this project is supported by the National Institute for Disability, Independent Living, and Rehabilitation Research. Next slide, please. Okay, our agenda for today, we'll talk about parenting with a disability and give you some background on the issues that parents face, some background on the Department of Health and Human Services Office for Civil Rights, and of course, go over the federal disability rights laws that are relevant, and talk about investigations, policy, and regulations. And last but not least, we'll give you some helpful resources. Next slide, please. All right, I'm going to turn this over now to Attorney Robyn Powell.
Thank you so much. So thank you all for joining us. I want to begin with some background on parents with disabilities before I turn it over to the real expert, Carla Carter from OCR. So just to give you some context, when we're thinking about parents with disabilities, I think it's really important that we think about it within the lens of a historical context, specifically looking at how we have always had laws and policies in the United States which have really tried to restrict people with disabilities from creating and forming families, And I think a good example, of course, is the eugenics movement, which really centered on three main ways to prohibit people with disabilities from creating and forming and maintaining families, which is institutionalization, sterilization, and marriage restrictions. So again, forced sterilization, of course, was very common, but we also had a number of states who had laws that explicitly prohibited people with disabilities from marrying, or that only allowed people with disabilities to marry over the age of 45, which is, of course, usually the end of one's sort of reproductive age. And yet, even today, we know that despite this history, an increasing number of people with disabilities are choosing to become parents. And, I think there's a number of reasons for it, but we're seeing sort of this increase in community integration. And because so many people with disabilities are now really living and working and playing in their neighborhoods, they all want what their non-disabled peers want, which is to have families, have relationships, and have children. And so, as we'll talk about, there's sort of this range in the number of estimates. Anywhere between 5 to 10% of US parents have a disability. And again, that number is going to continue to increase. So here is sort of just some estimates on sort of who are parents with disabilities and their children. And you can see that the ranges are, again, from about 5% to 10%. It's interesting to also note that about 10% of children in the United States have a parent with a disability. So again, this is a really significant and sizable population. And again, I just want to emphasize that it will continue to grow. So it's important that we focus on these issues. Just to give you a little more context, parents with disabilities experience really significant discrimination within the child welfare system, which I'm sure is not a surprise to most of you on this webinar. Estimates range from about 70 to 80% of parents with intellectual or psychiatric disabilities have their children removed. We also know that parents who are deaf or hard of hearing or who have physical disabilities also experience really significant high removal rates and loss of parental rights. A study from a few years ago that found about 19% of children in the foster care system in the United States have a parent with a disability. So remember that it's about 5 to 10% of parents with disabilities have a 10% of parents have a disability, and yet 19% of children in the foster care system have a parent with a disability, which shows sort of the significant disproportionality. We also know that disabled parents have a 22% higher odds of having their parental rights terminated. And we know that once a family is involved with the system who has a disabled parent, we know these cases are more likely to be substantiated, and these families are less likely to receive family preservation or reunification services when we compare them to families of non-disabled parents. And we know that there are a number of sort of recurring barriers that we see within the child welfare system as relates to disabled parents. We know that a number of states include disability as grounds for termination of parental rights. In fact, a recent analysis from the Parenting Center found that 42 states and the District of Columbia currently include disability as grounds for termination of parental rights. And there is a map on our parenting site website, which will show you which states those are. We also know that the Adoption and Safe Families Act has a number of provisions that, while not specifically calling out parents with disabilities, do have really disproportionate impacts, particularly as we think about sort of the timelines that are imposed because of the Adoption and Safe Families Act. And there is sort of these perceived limits on how the ADA applies, particularly with respect to termination of parental rights proceedings. And a number of cases historically found that the ADA did not apply, but I think it's important. We are seeing some movement in the courts and some recognition of the importance of the ADA and the application of the ADA in these cases. We also know that just parents with disabilities, especially parents who have psychiatric or intellectual disabilities, experience a number of barriers related to getting legal representation, particularly retaining attorneys who are really, knowledgeable about the ADA and how disability rights should be protected in the areas. We know that there are a number of access barriers, attitudinal barriers. Parents with disabilities face significant and pervasive bias and speculation within the child welfare system. There's a lack of awareness in training and skills, particularly in the courts and amongst clinicians, those that are doing the parenting evaluations and the child welfare system more broadly. So there's a lot of work to be done in this area. And now I'm turning it over to the main event, Carla Carter.
Thank you so much, Robyn, and thank you, everyone. Looks like there's 126 of you guys that have joined us today. So thank you so very much for the opportunity to talk with you a little bit about how the Office for Civil Rights can assist in advancing the rights of parents with disabilities. Next slide. So what is the Office for Civil Rights? Well, we are the law enforcement arm within the U.S. Department of Health and Human Services. This is the federal agency that primarily funds health and human services institutions. And so we are responsible for enforcing a number of federal civil rights laws, conscious and religious freedom, health information, privacy, security, and breach notification laws. So we do both civil rights, conscious and religious freedom, and HIPAA laws, which we largely talk that we enforce HIPAA laws. Let me just leave it there. And a lot of our work is conducted through complaints. We receive individual complaints, complaints from institutions, compliance reviews, which allow us, through our own authority, to investigate systemic issues. It is always our goal to seek voluntary compliance or corrective action. We provide technical assistance largely to entities that are under investigation, but we sometimes work within HHS to inform them of civil rights obligations. We do technical assistance, public outreach and education. Events like this are really important because you are the folks who are doing the work. And then we always try to issue guidance on our laws, particularly when there are some changes, and issue some regulations. And so I will talk about near the end of the presentation a really new regulation that we hope to have finalized by the end of the year. Next. So this is just a snapshot of the main laws in which OCR enforces. And these laws prohibit discrimination on the basis of race, color, national origin, disability, age, and sex. For today's presentation, we're just going to focus on federal disability rights laws. Next. So a question that constantly comes up when we're engaging with covered entities, and these are entities that are in the work of child welfare. The question we regularly get is, well, who's protected? Well, federal disability rights laws protect nearly everyone who comes in contact with the child welfare system. So we're talking about kids and their parents. We're talking about relatives, fictive kin, those folks who are family, but not biologically family, legal guardians, caregivers, foster parents, adoptive parents, and prospective parents and prospective adoptive parents. And so these laws really provide protections to all of these individuals, which is really important. And it's a good piece of information to take back as you're working with families that have disabilities. It's important to know that they may be entitled to some protections as well. Next. So this is a short list of child welfare providers, whether it's a state or county agency or private nonprofit child placement agencies. All of these entities provide critical services and supports to families in the child welfare system. These entities are subject to non-discrimination requirements by virtue of their receipt of receiving federal financial assistance from HHS, either directly or indirectly. And when I say federal financial assistance, let's talk about its Title 4B and E funds, its TANF funds that many states are drawing down to support families, block grants, Medicaid, as well as state court improvement program funds. And so just for your awareness, many courts also have, dependency courts have non-discrimination requirements by virtue of their receipt of federal financial assistance from HHS. when we're thinking about what programs or activities are covered, we're really talking about everything that child welfare agencies do. So whether it's CPS investigations, safety and risk assessments, child removals, placement, family preservation services, voluntary placements, it really is quite a wide range of activities that must be in compliance with federal disability rights laws. So for purposes of today, we will focus just on the disability rights laws. And so I think it's important to say that disability non-discrimination laws require that many determinations regarding people with disabilities be individualized, including but not limited to whether a person has a disability, whether a person with a disability poses a direct threat, and whether a person with a disability has a right to an accommodation or modified services. Section 504 protects qualified individuals with a disability. And so for purposes of this law, the person must first have a disability, and then they have to, in order to be qualified, they have to actually be eligible to participate in the service or activity that's provided by a recipient. And so in the context of child welfare, it is important that the person first have a disability, but also that they qualify for services that the child welfare agency provides. And so if we're talking about an individual who has a disability, but they have no reason to be involved with the child welfare system, either they're not a child or someone who's seeking services with a child or seeking to become a foster or adoptive parent, why they would be a person with a disability that is recognized by the law, they wouldn't be entitled to the protections because they are not qualified for the specific program. Section 504 applies to any entity that's receiving HHS funding, including state and local governments and their sub-agencies. And Section 504 can apply to an entire entity, even if the institution has only received funding for one component. And so the way we like to look at it is if you receive $1, you have the obligation. Next. Next slide. Okay, nope, sorry, one back. Right. The Americans with Disabilities Act has much broader coverage than Section 504 because it hits a lot of entities that 504 does not. And it's not coverage under the ADA is not contingent upon receiving federal financial assistance. It is contingent upon the relationship. So in this instance, Title II of the Americans with Disabilities Act requires that state and local government agencies and their sub-agencies comply with the ADA, irregardless of whether or not they receive federal financial assistance. The ADA's coverage is quite broad, and the ADA amendments have made it a lot easier for individuals with disabilities to qualify for protection. In the context of the child welfare system, Title II prohibits disability-based discrimination in all child welfare programs, services, and activities administered by a state and local government. And if you'll notice on the slide, the language of the ADA really closely mirrors that of Section 504. You still have to be a qualified individual with a disability to be protected in this. So that is something that's consistent, but because the ADA prohibits discrimination by public entities, that's what makes it somewhat different. So one of the things when I'm doing a lot of outreach, I'd like to emphasize this point that federal disability rights laws, the ADA and Section 504, require that covered entities, in this case, we're talking about child welfare entities or those programs and activities that support child welfare, provide effective and meaningful access to programs, benefits, and services. by providing auxiliary aids and services at no cost to the person with a disability, or making reasonable modifications as needed. And so we try to focus on effective, because just providing any accommodation or modification is not going to be the same. And so it really gets back to this point of, when working with people with disabilities, we're looking at what is effective for that person, not effective for a class of people. What is meaningful access for that person? And so I really try to drive home that point, particularly when I'm working with state agencies, so that they understand that, yes, you may be providing all of these great services that are accessible, but are they accessible to the individual that is seeking the service at issue? And so that's really important to raise, to keep that in mind. And as you're advocating on behalf of clients or family members, that you're thinking about whether or not the service that's being provided is effective and meaningful. Next slide. So reasonable efforts is something that many of you are familiar with. It requires Title 40 agencies to make reasonable efforts to preserve and reunify families when safe to do so. And I'm only focusing on the first part of that, right? Generally, these efforts consist of accessible, available, and culturally appropriate services that are designed to improve the capacity of families to provide safe and stable homes. That's like textbook from the federal regs. So we like to look at reasonable efforts as a complement to federal disability rights laws. They support each other because they both require that 4E agencies make individualized determinations about people. Federal disability rights laws require individualized determinations about a parent with a disability that is based on reliable facts and objective evidence about the person's needs. So in order to ensure that a person with a disability or a parent with a disability has effective and meaningful opportunities, say, to achieve the goal of reunification, a child welfare agency would be required to provide auxiliary aids and services at no cost, or to reasonably modify their policies, programs, and practices to meet the needs of a parent with a disability. So that's how a child welfare agency would be in compliance with federal disability rights laws. Now, tying it to reasonable efforts is that, Section 504, like to give you an example, Section 504 in the ADA would require that a state child welfare agency refer a parent with a cognitive disability to a parent coach that is trained to work with this population, in order to ensure that the parent has an effective and meaningful opportunity to learn the skill that the agency is seeking them to provide. The agency could also meet their requirements under reasonable efforts by demonstrating that they actually referred someone to a program that meets the parents' learning needs. So they are complementary to each other. And sometimes, as we've had discussions over the last couple of years, trying to tie these concepts, we've got a little bit of pushback from folks like, well, reasonable effort doesn't require it. Well, if you look at the language of reasonable efforts, it talks about accessible, culturally appropriate, and available services. And the next one. So how can OCR help? Well, in addition to our policies and our regulations, the meat and potatoes of our work is our enforcement and compliance activities. We can investigate complaints that can be filed by any person, either by mail or electronically, for any violation of federal civil rights laws. But the caveat here is that complaints must be filed within 180 days of when someone knew or should have known that an act of discrimination occurred. But there is an opportunity for OCR to waive an untimely complaint for good cause. It is important that if an incident occurred outside of that 180-day window, that really the complaint lay out the basis for good cause for waiving the untimeliness. OCR can resolve complaints informally. We have a process called early complaint resolution, which would allow us to serve sort of like a mediator, but not a mediator, to bring parties to the table to resolve some issues that may be preventing a child from going home, or even ensuring that parents are having opportunities to have reasonable family time. And so in the ECR process, which is the main informal way of resolving a complaint, both parties would have to agree. And so if we have a parent that's willing, but a child welfare agency that's not, OCR could not mandate the child welfare agency to participate in ECR. At any point during a complaint investigation, OCR may suspend its activities if we're able to achieve voluntary resolution agreement, or we can continue with a full investigation and issue a letter of finding. And it could be that there is no discrimination. It could be a finding of, we think that there's discrimination, but we haven't reached, there's not enough evidence, but there's certainly compliance concerns. Or we can find that there is an actual violation, which would trigger a number of activities that the other covered entity would have to engage in. We can initiate compliance reviews under our own authority to look at comprehensive systemic issues. And so as we go through some of the examples, you'll see at least one case in which we saw something in the media and thought that this was something that we should be looking at. Usually our compliance reviews resolve through a voluntary resolution agreement where we work with the state agency to take certain steps to ensure that their programs are in compliance with the laws. There are specific time periods for a voluntary resolution agreement, as well as a monitoring period is almost always imposed of anywhere from 1 to 5 years. And then there's the formal enforcement, where we would issue a letter of finding, which can lead to suspension of funds or action filed on behalf of OCR by DOJ. Next. So this slide just will give some links to how to access our complaint portal. I think we still have a fax machine. I feel like that's kind of old school, but you know, who knows? I think there might be one in the office next to me. But these are this is all of the information you would need to file a complaint. Our website has a really great information, and as well as the complaint portal, there's a document there that explains to you what happens when OCR accepts a complaint for investigation. Next. Just a quick visual of how our complaint process is. Every complaint that we receive does get triaged and reviewed by someone in our regional office, which I should have mentioned. We have 8 regional offices that cover every state in the United States as well as territories. And so in this, as you can see from this flow chart, we could do a complaint intake and review. We may resolve it because OCR doesn't have jurisdiction, the complaint was untimely, but good cause wasn't established, or we may not have jurisdiction. In some instances, it may be very clear that another federal agency has jurisdiction, and we would refer it to the other federal agency. But either event, the person would receive a letter from OCR indicating the disposition, or we can investigate the complaints, and that would be looking at possible civil rights violations. We do the investigation and determine whether one of these 3 resolutions were appropriate. Next. So interesting fact, and sad nonetheless, between 2015 and 2021, OCR received over 300 complaints from parents with disabilities and advocates alleging disability discrimination in 34 states. We're pulling our numbers now. I'm pretty sure that we've exceeded that number, and many more states are involved. Our complaints that we receive tend to be from parents with intellectual disabilities who've had their infants removed from them at the hospital based on stereotypic beliefs about how whether a parent with a disability can safely care for a child. We've seen complaints involving parents who were denied sign language interpreters. It's so interesting that we're still seeing that as an issue, but it continues to happen. And then another large number of complaints are from parents and advocates who assert that child welfare agencies are prohibiting parents with disabilities from using their professional and natural supports to help them with childcare experience. And so one of the things that, especially when I'm doing an in-person presentation, I often say to folks, how many of you, by show of hands, were just born with this natural ability to parent kids? There might be one person in the audience, but we all know that parenting skills don't come naturally to everyone. And when I look at myself, when I became a parent at 25, thank God my mother, my sisters, my cousins, my aunts were there because I was a mess. I didn't know much, and I didn't really play with dolls that way. So it was really important. And so, as we're talking with child welfare entities and those that support child welfare agencies, we're reminded that, families have professional and natural supports, and they are a reasonable modification to any policy that would prohibit that. And we know that child welfare agencies do not prohibit families from getting involved. And so it's just a certain class of individuals that don't always get that, folks have questions about their involvement. Next. And so these are, some of the highlights of investigations. Some of these are on our webpage. I think most folks should be familiar with our letter of finding against the Massachusetts Department of Children and Families. It's the first time that OCR and DOJ jointly issued a violation letter indicating that a child welfare agency violated federal disability rights laws and how they denied a mother with a disability opportunities to preserve her relationship with her daughter, as well as to reunify over an extended period of time. As a result of that violation letter of finding, OCR and DOJ have worked with the state of Massachusetts to resolve all compliance issues through a settlement agreement. A settlement agreement is different from a voluntary resolution agreement because in those instances, the federal government dictates the terms of what is the steps that the state needs to take in order to comply. But of course, we're reasonable and understand that, many states have limited resources. And so we do try to work within the confines of what the state is able to do, but still resolving those issues. Around the time that we were looking at Massachusetts, we became aware of two parents in the state of Oregon that had their children removed from them because of their disabilities. And we did an on-site investigation. So in this case, we did not have a complaint. We opened up a compliance review to see what was happening. Most of it focused on the parents, but we also looked at the systemic issues that were going on. And as a result of some of the compliance concerns we identified, Oregon agreed to enter into a voluntary resolution agreement with us to resolve some of those issues. And one of the things that Robyn pointed out very early on was that, you know, a lot of times we have folks who are working in child welfare that may not have received training on federal disability rights laws or any civil rights laws. And so in that case, OCR did a train the trainer with their staff so that they would understand, you know, that Oregon would be in the best position to communicate that information to their social service staff. We also resolved 2 cases involving New Jersey and the North Carolina Department of Health and Human Services through corrective action. So in this case, we did not enter into an agreement, but we got both of those entities to agree to take certain steps before we close our case. And so that was an effective approach to addressing discrimination issues. We, I think it's maybe about a year ago, we entered into agreement with Rhode Island to resolve violations of the ADA in Section 504 in their child welfare system. In that case, parents with who were deaf or hard of hearing were not receiving effective communication. And so that agreement required them to take many steps to address that, as well as to provide training to their staff and to update their policies. And then a newer feature of our work, particularly during the opioid epidemic, you know, we began to notice that child welfare agencies were removing children from families at really high rates. And in the mix of those families were parents who were in recovery from a substance use disorder and receiving medication-assisted treatment. So they were being viewed as the same as someone who is engaged in the illegal use of drugs, and it is different. People in recovery from a substance use or alcohol use disorder are protected if they are no longer engaged in the illegal use of drugs. And individuals who are in recovery from a substance use or alcohol use disorder and are receiving medication-assisted treatment, as long as they're no longer engaged in the illegal use of drugs, are also protected under federal disability rights laws. Oops. So just 2 policy documents that you can find on our webpage is Protecting the Rights of Parents and Prospective Parents with Disabilities. This is a comprehensive technical assistance document that we issued in 2015. I was very pleased to find that some attorneys in advocating for their clients just attached the technical assistance to a brief. I encourage you to do so because we've been cited, this technical assistance has been cited in some local decisions. And then the Title VI guidance addresses Title VI protections for people involved in the child welfare system as well. So the really exciting piece of all of this is that we have listened to what you and the NCD and many organizations have asked for, which is to update the 504 regulations to reflect what is currently happening today. Our regulation was initially rolled out in 1977. The world was a lot smaller. Discrimination looked a lot different. And while the Section 504 has always applied to child welfare, the child welfare system and courts, the child welfare system and courts did not see themselves in this rule. And so we did them a favor. We wrote some provisions that are specific to child welfare. So in the discrimination on the basis of disability and health and human services programs or activities proposed regulation, we define who a parent is, caretakers, companions. So we make that very clear and plain. We also clarify that a qualified person with a disability is a person who meets the essential eligibility requirements of the child welfare program. We clarify that programs or activities include all operations of child welfare, and that non-discrimination requirements relate to child welfare decision-making. So, for example, in our proposed rule, we say explicitly that the rule, Section 504, expressly prohibits discrimination in decision-making, specifically decisions based on speculation, stereotypes, or generalizations about a parent, caregiver, foster parent, or prospective parent with a disability, as well as discriminatory decisions about a child with a disability. So that's the first time we've ever said anything like that. And we know that a lot of the discriminatory conduct that we see is based upon what people believe rather than what they know and what they see. And one other point is that another provision, and this is, again, it's a proposed rule, so we still have to go through rulemaking. Child welfare agencies may not file a petition to terminate a parent's legal rights to a child that is based on speculation, stereotypes, or generalizations about the parent's disability. So we know that there are a number of states that expressly use the term, use disability in their regulations, which, you know, may be appropriate under some circumstances. But if a child welfare agency is filing a petition based solely on speculation, generalizations, or stereotypes about a parent with a disability, that could violate Section 504. Next. So here are a lot of resources that are available to you. OCR has a child welfare page where we put in links to our guidance, as well as some training materials. There's the HHS opioids page, which is always a great resource. The Assistant Secretary for Program and Evaluations has done some really interesting studies on child welfare, and so there's some information there. And then I encourage everyone to look at the National Center on Substance Abuse and Child Welfare. They're the Technical Assistance Center for ACF and SAMHSA that helps the state agencies come into compliance with, you know, all of the standards around infants who've been exposed to substances. And that's our contact information. And I think that's it for me. Thank you, everyone.
Thank you so much. That was incredibly informative, and I'm sure it will be really helpful to our audience today. I want to tell folks about a couple more resources. Of course, there's our National Research Center for Parents with Disabilities, and we have a lot of resources for attorneys and parents and anyone interested in parenting with a disability. There's also the Disabled Parenting Project, where parents can communicate with other parents about the parenting experience and get tips and tricks to make it work better. The publication that was authored by Robyn Powell, Rocking the Cradle, Ensuring the Rights of Parents with Disabilities, which is very informative. The Child Welfare Information Gateway, the Association of Successful Parenting, which provides training for social service providers on how to work with parents, and the Bazelon Center for Mental Health Law. Next slide, please. If you want more information, you can contact us in addition to Carla Carter. This is our contact information online. Next slide, please. And now we have some time for questions and answers. We have about 15 minutes. Let me just say that before we get too deeply into that we would really love your feedback. As I mentioned before, it's at the beginning of the chat, but Wendy, if you could put that in the chat again here, I would really appreciate it. So the first question is, do you have any specific training resources, i.e. guides to use or as a template to form a training program to educate the courts and child welfare agencies about how to interact with children or parents with disabilities?
So we don't have a template, but online, one of the resources is it's a two-part webinar that on protecting the rights of individuals in, let me get it right, because I had to know this all the time, right? It's protecting the rights of parents in recovery from substance use disorder. So the first webinar is maybe about 25 minutes, and it provides a high-level overview of federal disability rights laws and how it applies to child welfare. The second part two, focuses on specifically parents with who are in recovery, and it explores, those specific rights for people in recovery, exceptions to when someone falls outside of protection of the ADA, and it discusses medication-assisted treatment. And when a person is receiving medication-assisted treatment, when they are covered and when they're not covered. And so the long and short of it is, a creative organization can copy our slides or can present them. Also, we're always open to coming and talking to courts. I think probably now every 2 or 3 years, we get accepted to do a presentation at the NCJ, FCJ, where all the judges get a lot of their training. But if there are other opportunities, I would love to hear about it. It could be with this rollout of the final rule, that we may do something, but I'm always a little cautious. So some years ago, we had done a online training and shared our slides on race discrimination in the child welfare system, and many organizations took that information and then added stuff in there that would have violated the law. So we're a little skittish about that, but I don't know if Brandeis or others would take that on. I think it would be a really good opportunity.
Linda, if I can just add, the Parenting Center actually has a number of trainings on our website for the child welfare system. And we are currently working on a whole training module. But we do have several webinars and fact sheets and things on our Parenting Center website, specifically for the child welfare system, for attorneys, and for some courts. But I think we're also always looking for more opportunities, particularly with respect to courts. And if I can just add something, because I saw a comment earlier and I wanted to point it out for Carla. Someone mentioned when you were talking about reasonable efforts, about active efforts for ICWA. And so for those who don't know, Indian Child Welfare Act actually requires a heightened level. It requires active efforts versus reasonable efforts. And I think they were pointing out that would also be relevant. Correct, Carla?
It would. Thank you.
Okay, so we have another question in the chat, which is that if a child welfare agency closes a parent's case without providing resources to assist a family, even though the family asks for assistance, could that be a cause of action? For instance, a parent asks for in-home medical assistance for a medically fragile child because they do not feel equipped to provide medical care due to the parent's own disability. Either one of you or both.
Yeah, it absolutely could. I think, when we're thinking about complaints, and I guess I should have just said this up front, a lot of times OCR gets roped in. We receive a complaint well after things have gone really, really wrong. And sometimes the parent's rights have been terminated already, or the child has been placed with a family member under some other legal guardianship or custody. That does not stop us from doing an investigation. We may not be able to help the individual get relief, depending upon whether the parent's rights are intact. But that doesn't mean that there aren't opportunities for us to ensure that other parents are not falling into a similar situation. But I would always encourage folks, if they're thinking about using OCR as a resource, any compliance concerns you're going to see is going to be at the very beginning. It's going to be during the investigation or the placement of a child that, someone is not getting, the services are not accessible or effective. And it's important to loop us in early because, once the courts are involved, our ability to get relief is a little bit more limited.
Robyn, do you want to add anything?
No, I think that's good. I have nothing else.
Okay, great. So next question, directed, I think, to you, Carla. Who at HHS headquarters can we contact when the regional office is completely unresponsive to questions about the status of a complaint we filed on behalf of a client?
That would be me. So one of the things, so before I became an associate deputy director for enforcement, I was part of the policy team. And so when I joined the enforcement team, one of the things that I was still able to retain is my role and involvement in child welfare cases. And I often say to folks, which may or may not, well, it may irritate some of my colleagues, is that if you want a complaint, if you want an immediate response on a complaint, send it to me. Because if I'm aware of it, then I can follow up. I don't get to determine whether or not they open a complaint, but I can certainly help our staff think through what needs to be done and, really be a good resource for them. So if you have not received any feedback from anyone, please reach out to me. My email address is carla.carter. I guess I could put it in the chat. Oh, maybe not. Carla.carter, and that's traditional Carla, C-A-R-L-A. I was born in the 60s. Carter, like Jimmy, at hhs.gov.
Great, thank you very much. Here's a question. Would the ADA or Section 504 require reasonable accommodations in the form of more time? How is this reconciled with the federal permanency timelines under the child welfare laws?
That is really a difficult, that is very difficult. That really is difficult. And I want to be careful. I think that as we're looking at an individual family, because I don't think that there is a blanket rule, we'd have to look at the individualized determination that this parent needs more time. And, that may be established in lots of ways. It could be outside providers who are saying that, yes, the parent is moving in this positive direction. And we would look at that as compelling evidence. I don't know that OCR can override what the Adoption and Safe Families Act says, but we would have to gel and probably have to do some consulting with our colleagues as well as our Office of General Counsel if we were seeking that as a remedy. But again, if we're asking OCR to get involved early rather than later, then I think more time happens. As long as we're in, there's more time. If we're coming in after the fact, particularly if TPRs have been filed already, it is, I think, a bit more difficult. I'd be interested to see what you think, Robyn.
Yeah, so I'm going to say I think there's an argument to be made, particularly because when we look at the timelines under the Adoption and Safe Families Act, there is a provision that says, you can extend this if reasonable efforts have not been provided. And I think that if you can make the argument that, I think there's, as you talked about, sort of that dovetailing reasonable efforts and reasonable accommodations. And I strongly believe that a reasonable effort is not reasonable if it's not accessible. So I think that there's an argument, and I'm not saying it's going to be a winning argument, but I think it's one worth making. And we have seen some courts, I think about the Michigan case in Ray Hicks from several years ago, where they explicitly, the Supreme Court said that dovetail language, and you cannot provide reasonable efforts if you're not making them accessible. And so I think using the two laws together, particularly because there is that an aspect that explicitly says sort of that it can be extended if there hasn't been sort of reasonable efforts provided. And the case I was talking about is in Ray Hicks out of Michigan. It's from, I think, 2017, maybe.
Thank you, Robyn. And here's a question. This may be our final question for today. Many times the Department of Social Services will state that they don't need any resources to address the disabled parent's needs. Is there a way to identify needed specific resources, specific resource providers? And this person, I think, is from Maryland. The courts in Maryland have indicated that DDS does not need to provide, quote, extraordinary, unquote, services. Thoughts?
I'd like to see that as a complaint. I'd
Mhm.
like to see that as a complaint. I'm not really sure what that means.
Mhm.
But I would certainly, I think we'd be very interested in learning more about that and perhaps even providing some education to the courts in Maryland.
Mhm. And
Yeah.
any suggestions for people who are looking for resources for their clients, if they're not familiar with disability services to begin with?
I think we have some on the Parenting Center's website,
Mhm.
that Center for Parenting, parentswithdisabilities.org, I think it is, but hopefully Amy or Wendy can put the link in, but
Mhm.
we do have some resources.
Right. And there are state agencies, of course, that serve people with disabilities. That could be one potential resource. The local protection and advocacy agencies don't tend to take cases, child welfare cases, but they may be able to advise you as to community resources in some instances. So those are possibilities as well. Let's move on to the next slide, please. All right, so many of you mentioned that you'd like to take additional training, and we have one coming up with Attorney Powell and also attorneys from the Disability Rights Education and Defense Fund. It's called the Keeping Families Together Training, Disability Law Training for Parent Attorneys. It'll be offered in two parts. The first part will focus on law. The second part will focus on legal strategies, advocacy strategies, and those two trainings will take place on March 13th and March 20th. From 2 to 3 p.m. Eastern Time. Your participation, of course, is totally voluntary, no cost. If you fill out our pre-test and our post-test, we're trying to test the efficacy of this training. You have a chance, 1 in 75 chance of winning a $50 gift card. Actually, that's a $250 gift card. $250. So if you wish to register, you can register at that link there. And if you have any questions, you can contact Taylor Merck at umassmed.edu. Taylor.Merck, that's MERK at umassmed.edu. Next slide, please. As I mentioned previously, this webinar was funded by the National Institute on Disability, Independent Living, and Rehabilitation Research. And we thank NIDLR, and I want to thank our panelists as well. And you've done a wonderful job providing a lot of very comprehensive information in a very short period of time. So thank you very much, everyone. And thank you to our audience as well for your attentiveness and for your really important questions.